about the limited circumstances in the state of Texas where you're allowed to get a divorce when one spouse is not involved in the process. This video will quickly run you through what that looks like. So basically, a default divorce is what it's called when a person is going to get a divorce, but they don't know where their spouse is located because perhaps you've lost touch, your spouse has moved, you've been separated a long time, perhaps they abandon you and you just have no way of finding them and you want to be divorced. This default divorce is how you go about that. Or often in Texas, a person is served via process server or other legal notice with the fact that there's a divorce ongoing, but that person, despite the fact that they have been served, completely ignores the process. You can still be divorced in the state of Texas. Your case, though, is going to be more complicated. It's going to be, again, what's called a default judgment divorce. A default divorce. A divorce taken by default because the other person that was supposed to answer, failed to answer. So if you're getting sued, you would want to know about it. Everybody would agree with that. In fact, you would feel that you had a right to know that you were being sued. And filing a divorce case in Texas or anywhere is a process of suing your spouse to be removed legally from the marriage. So because a divorce is a lawsuit, your spouse has the right to know that you are pursuing a divorce. So the reason why a default judgment divorce, a divorce without your spouse, is harder is because before the judge is going to sign off on that final paper and grant your divorce, you have to prove to that judge that you have taken every step reasonably possible to notify your spouse that you are pursuing a divorce so that they can participate in the process if they want to. If the judge is not convinced at the end of your case that you have not done what you're supposed to do to notify your spouse of the fact that you're pursuing a divorce, the judge is going to deny the case and you will not end up being divorced. So a pertinent part of your lawyer's job in a default judgment divorce is to do everything, every little step that's involved with a regular divorce case, but then also to bring extra evidence, more things to show that you also notified your spouse. Because keep in mind, in an agreed divorce, your spouse, of course, was notified. The court knows that because your spouse has signed off on the final decree or signed off on a waiver of service. But in a default judgment divorce, there will not be a signature from your spouse. Your spouse is not involved. The reason why a regular divorce or an agreed divorce is going to cost less in legal fees than a default judgment divorce, you have to visually see the difference. An agreed divorce involves these two forms, a decree and a petition, okay? A divorce by default requires all of these forms. Decree, petition, last known address affidavit, affidavit of military service, certificate of military status, service of process request, and an affidavit in support of service by publication. So there's more time involved with just getting that divorce to the requirements that the judge is going to need in order to sign off on it. So in that one affidavit that you had to do up here, all of this data is needed, and somebody has to get that information from you and then put it in legal form and then make sure that you've signed and notarized it properly so that the judge doesn't reject it. And these are some kind of common sense things, what it would take to actually find somebody today if you don't know where they are and you're trying to notify them of a lawsuit. Have you called them? Have you emailed them? Reached out to their employer if you know them? Facebook, their family, friends? Have you tried contacting the local jail in case they're in jail? Have you checked obituaries? Have you checked just by sending a letter? You have to show that you tried to reach them. And that's what the purpose of that affidavit is. So if any single document that is up in that list up there is wrong, then the court is going to reject your case. So more time is needed in the divorce. Another important thing to know about a default judgment divorce is that it is almost impossible to make it so that the matter cannot be appealed. And even if you follow every single rule, often just out of purposes of equity, if your spouse comes and tries to open the matter, the judge will allow it to be reopened. There are some steps that can be taken to avoid the appeal possibility. Appealing, of course, is when you finish the divorce and then your spouse comes back and tries to reopen it because now they don't agree and they now want to be involved. So there's things that you can do. You could try to make sure that your decree divides your property fairly, make sure that the decree is in the best interest of the children set up if your children are involved or if there's children, that child support is within guidelines. It's totally imperative that a record is taken at a default judgment, or otherwise it can be appealed as a matter of law. So a record has to be taken with a court reporter. Judges can be suspicious of default judgment divorces. So more is needed. That's what you should take away from this video. More is needed to get a default judgment divorce. Now, there are other advisable steps because you don't want to get yourself in a situation where your spouse actually wanted to be involved in the divorce and you defraud them out of being involved, which spouses will accuse others of, and there's several cases in Texas that prove that. So situations that can make it suspicious that you're defrauding your spouse could be that you have them served with divorce papers, but then you continue having a romantic relationship with them. That could mean that your spouse thought that you guys were reconciling, so doesn't answer the divorce, and then you go ahead and you end up getting a divorce. Anyway, they could say that that is fraud and reopen the case. You don't want to continue living with your spouse if you're pursuing a divorce by default. Okay, so these are just some advice that will help you from cases that we've seen going on in Texas. If you want to take all possible steps necessary to avoid your spouse being able to accuse you of not informing them, and this is more in a situation where you do know where your spouse is, you've had them served with a process server, and now they are refusing to be involved in the process. We do see cases like this. We, of course, see them every year. And so these are the steps that you can take with this day and age, your smartphone, to really protect yourself. You need to video record yourself advising your spouse that you're pursuing a divorce. And you need to video record yourself telling your spouse several times that you're pursuing a divorce during the case, not just at the beginning, but several times, so that they can't claim you told them you were reconciling after you filed. Now, also, you want to make sure that your spouse knew about the divorce. So that's why you do this with the video recording, and chose to ignore it via conscious disregard. So if you video record it, you also need to say and tell your spouse that you have hired a law firm to help you with that default. You don't want your spouse to come back later and say, well, I didn't know they had a lawyer and we're actually pursuing it. I thought we were just talking. You need to tell them everything up front on video, and then the judge is much less likely to sympathize with your spouse afterwards and keep the matter closed for you. Now, when you go to court, you need to tell your spouse you're headed to court to take a default judgment divorce, and you need to get a certified copy of your decree at that hearing and bring it back and hand it to your spouse, and take a picture or a video of you handing that decree, so that there can be no question whatsoever that you involved yourself in this process. Your spouse would not. We realize that some of these pieces of evidence would be virtually impossible for you to collect, but we're just showing you an ideal picture of what the evidence would look like to win a case that you did a default and then they're trying to appeal it. You need to know, before you hire a firm on a default judgment divorce, that if you don't take these steps, it can be in some courts in Texas virtually impossible not to have your matter appealed if your spouse timely tries to appeal it after you've taken a default, which means that default judgment divorces are not ideal. The ideal situation is where your spouse's whereabouts are known and they are participating in the process. But sometimes that is just an impossibility. Now, what I want to tell you is we've told you all the cons about a default judgment divorce, but you need to know that they happen every day. In Bexar County and in other counties of Texas, they happen every single day. So it's not that it's totally out of place to pursue a default judgment divorce in the proper circumstances, but you do need to get the right legal help to analyze whether it is appropriate and to walk you through every single step so that you can assure that all your hard work pursuing your divorce is not lost, and that at the end your divorce is granted. So thank you for stopping by and learning more about default judgment divorces here in the state of Texas.